the statement made by Mr. N.J. Khatania, learned advocate for respondent number 1, that the order passed by this court has been complied with, this petition is consigned. In the event of such a statement not being true, it will be open for the petitioner. It will be open for the petitioner to revive this case by filing an affidavit to that effect.
Obliged.
Item 3.
It is your lordship. Lordship, the SLP filed against lordship's orders, my lord, that is still pending, my lord. Yes, my lord.
Let this matter be listed on. Give a date in June for the pendency of the SLP. For the pendency of an SLP with respect to the same matter before the Supreme Court.
Deeply, sir.
19 June. Item 5.
In this case, there is a delay of 160 days. Opportunity was given for us to give paper publication, which we have done. Prior to that, the notices could not be served because the addressees were not found. Now, on the last occasion, Lordship was pleased to grant one more chance to the other side, whether they would like to.
Despite substituted service of notice, there is no assurance on behalf of the respondent. In that view of the matter, let this case be listed as a complaint matter. In that view of the matter, in that view of the matter, we have gone through the application seeking condonation of delay of 160 days in preferring locally. Good reasons have been shown, and we are inclined to condone such a delay. The delay is condoned. The application stands allowed. Let the appeal be processed and be listed, preferably on some date in June. No urgency.
Urgency is in the month of May, last part of May, Lordship.
Last of
Deeply oppressed.
29th May. Item 6.
service to one. Phone number, not sure. Awaiting the report regarding service of notice on sole respondent. The matter is Judge Joseph. You are appearing for the
I
respondent.
am the respondent, my lord. My lord, here, order has been complied, my lord, as per my instruction, my lord.
The order has been complied with.
Speaking order has been passed.
You are-
by the-
Since the order passed by this court has already been complied with, this petition is no longer required to be adjudicated. The case is consigned.
Master.
Item number 7.
We have heard so and so.
Right, legal. I appear on behalf of all the respondents in this matter on instructions, my lord. I'll be filing my call number during the course of the day. What I have been informed by the authorities is that the order has already been complied with, but I do not have the written instructions. So, Lordship, can you give me some time to bring all
I
this?
got over for the day. Take instructions. Let it not remain on board unnecessarily.
Well, yesterday evening, my client telephoned me saying that nothing has been found to them. No question compliance, nothing has been found.
Let be posted on Friday, my lord. I'll
Let this matter
bring on
come
my
up for execution
everything.
under the same heading.
It has been complied with.
Give a date of Friday.
24/6. 24/4.
24.
Friday.
Friday.
Obliged.
Item 8.
Similar matter it's on your lordship yesterday, my lord, on 22/6/2000. Yes, sir.
Here, my lord, the SLP itself is pending. In the other cases, a review was filed against dismissal of the SLP. Here, the SLP itself is pending.
Then they make a resolution. We are let this matter be, Mr. Patrick, standing counsel PSN submits that the SLP petition has been filed before the Supreme Court. He therefore seeks a short adjournment. Time is granted. Let this matter come up for execution. July.
Much. All right.
15 July. Item 9.
This matter, my lord, notice was issued on 22nd of February.
Awaiting the service of notice from the respondent. Awaiting the report regarding service of notice from the full respondent. The matter is adjourned to July.
17th July. Item 10.
In this case, there is a delay of about 800 days. They have filed the objection. I would like to request this honorable court to fix the matter for hearing on the delay application sometime in the second week of May, lordship. Today I have to rush to the airport now.
But service is not complete in respect of
Yeah, yeah.
21 and 25.
Yes, my lord, so far as these three, what I've been repairing for all
John, you are appealing for which all respondents?
my lord, all the responded except my lord 3,
12, 21.
21, 12 and 25. 21 has already expired.
12, 21 and 25.
20,
If you obtain their Wakalatnama also, will fix another date for hearing.
my lord, so far as the respondent number 21 is concerned, he has already expired, my lord. And so far as 12 and
12 and
20
25.
12 and 25, my lord, they are not in touch with the other respondents for 2 years. Perhaps they are in.
But they have been issued notice.
They will issue.
Is there a report regarding service of notice?
No.
Report is not. Again. This court has been informed that respondent number 21 has left this world of living. In that way, the matter. In that way, the matter. Without any of this information. Left the world of living. In that way, the matter, an application will be required to be filed on behalf of the applicant for expunging his name from the array of parties. Mr. M.K. Chaudhary, learned senior advocate, has appeared on behalf of all the respondents except respondents number 12 and 25, regarding whom there is no report on record with respect to service of notice of death. Awaiting the report regarding service of notice on respondent numbers 12 and 25. The matter is adjourned to June.
Yes.
June.
8th June.
File an application for expunging his name.
Lordship will do that.
Item 11.
There is a delay of 515 days.
Not 5 objects.
No response has been filed.
Yes. Who appears for the respondents?
Public health engineering, general counsel.
Public Health Department. All officials. Why you want this delay to be condoned?
Lordship, I am for accountant.
Who appears for the state respondents?
Department.
Standing counsel, finance and standing counsel, PH.
Sumitra Sharma, you are appearing for respondents number 1, 2, 3, 7, 8, and 9. Concede, then
It's PHC.
Lordship.
PHC.
It is PHC.
Department is PHC.
Standing counsel.
They have a set of standing.
Delay कितना है?
15 days.
Application allowed. There is no response, no effective opposition from the respondents, from the state respondents. Detailed elements of marriage. Appeal to be processed and be listed, preferably on civil side.
15th June. Item 12.
Delay of 210 days, my lord.
I filed my objection.
Yes.
Lordship, I filed my objection, Lordship. Kindly consider that, Lordship. There is no such explanation, Lordship. And 194 days they have spent, Lordship.
We condone the delay of private parties. The state is also sealing in the same boat. For
Lordship.
state, take it from.
Lordship, my objection may be
Your
kindly,
objection shall be taken note of.
Lordship, kindly consider that. My objection.
File your.
I already filed my objection, Lordship. In the.
No, you file your appearance slip.
Lordship,
File your appearance slip.
Lordship, please.
Obliged, lordship.
76. Item 13.
That is about it. So in this case, delay of 68 days.
Notice,
No. Standing counsel, yeah.
He said,
so 68 days delay,
yes,
who appears for the respondents?
I do, Lordship. I appear on behalf of Mr. M. Smith, Lordship, for the ESIC. Lordship, we've received instructions to file an objection, Lordship.
Mr. So and so, there's an application seeking confirmation of delay of so many days, of 68 days in preference of the appeal. Mr. So and so has appeared on behalf of the state respondent. Submitted with affidavit in opposition. With respect to such a prayer for confirmation of delay shall be filed positively by the next day. Re-notify 3 weeks. 3 weeks not like the date leave.
10-6.
Hello, grateful, Lord.
Supplementary list for orders for item number 41.
These are lordship. Matter, the newspaper publications has already been effected on 11/4. A copy, I have a scanned copy of the same, but we are yet to file the affidavit. So I'm
File
seeking,
your affidavit.
yes, your lordship, the originals are awaited in a newspaper.
We adjourn this matter for 2 weeks. File your affidavit, then we'll say which else. Yeah,
Ledger.
let this matter come up for consideration on the same on.
28 May 20. Item 42.
Yeah.
Not with the lordship, my lord.
Yes.
This matter, my lord, steps were taken, my lord. But I have seen the, my lord, report of the office, my lord, it says that nothing has been returned, my lord. Under circumstances, my lord, the deemed service may be considered, my lord, and the delay may be condoned, so that I can place the appeal on
Delay of
merit.
how many days?
There's a delay of 1,276 days, but my lord, the delay has occurred because even though I was a party, notice was not issued to me, my lord. Later on, my lord, at the behest of my brother, I had come to know about this order, my lord.
We'll give one more time.
My lord, the problem is that, my lord,
There's nothing in the tracking system also.
yes, my lord, but then, my lord, my lord, my problem is, my,
Date you tell us, Mr. Chairman. Waiting the report regarding service of notice on newly added response number 1.1 to 1.5. Give a date after, give a date sometimes in June.
can it be in the month of May, my lord?
Let it be in June, on that day, we will.
But my-
1,000 days delay.
My only problem is that my boots are wasting inside that, my lord, shop, I am not being able to open it also. With all the rainwater and everything, my lord.
June.
In the first week, my lord.
June first week. All right.
I am deeply overwhelmed.
5-6. Thank you. Item 43.
My lord, in pursuant to the last order, that is 25/3, my lord, all the state has to respond, my lord. But only Mizoram has filed an affidavit.
Yesterday I have filed.
My lord, I am from the state of Nagaland. I have received instruction and monitoring the state level has already constituted, but due to shortage of time, I could not file. Give me
Has the monitoring committee in different states been constituted?
lordship. It has been.
When will you file your affidavits?
2 days time, my lord.
2 days.
We will
later.
file it, my lord.
You have filed your affidavit.
Mizoram already filed.
And that's some.
Assam, what,
And who appears for Assam?
Mr. Dipakana.
Mr. Barua, you don't require our invitation.
No, I'm sorry. Just taking out that.
You know, necessary affidavit. The affidavit on behalf of state of Mizoram has already been filed. I must quote that. The state of Leonard, your government advocate is here. Additional advocate general for Nagaland.
My lord, additional, my lord.
State code and additional advocate general for the state of Nagaland. Submitted that the affidavit shall be filed on or before the next vote. Who is the prayer made on behalf of the state of Mr. Barua, learned standing, you're a standing counsel.
Is the permanent.
The learned government advocate person submits the next day. The required affidavit shall be filed on behalf of the state. Let all these affidavits be positively be filed by the next date, notified July.
Obliged.
28 July. Item 44.
Your Lordship, I am appearing for the petitioner in item
Yeah.
44.
Yes. Have you taken steps for service of notice?
Your Lordship, there has been a discrepancy in the services of notice. Although, Your Lordship, para 3 of my application, Your Lordship, there is no actual delay in filing the petition, Your Lordship. The cause of action.
That is something which you will decide. But when notices were issued, have you taken steps?
Your Lordship, there has been inadvertence on my part, Your Lordship. I'm out of station.
Then we'll
Lordship,
dismiss
grant
this
me another opportunity to.
Just a minute. Notices have to be issued to respondents number
One.
respondent number one. You're appearing, Mr. Gupta, you're appearing for whom?
2 to 5. Respond number 2 to 5.
2 to 5. And who is respondent number one?
The private party, Manoj.
Again, response number 2 to 5 are represented by Mr. H. Gupta. Mr. H. Gupta, learned advocate. It appears that no steps have been taken up till now for issuance of notice on respondent number 1. The learned counsel appearing for the applicant submits that necessary requisite shall be filed within a week for issuance of notice on respondent number 1. In that case, notices shall be issued to respondent number 1 by both modes, returnable on so and so date. Your date sometimes in June.
Your Lordship, may listed in May, kindly, Your Lordship. It is.
Do your part first.
Yes, sir.
First file, do your part. Otherwise, you would have dismissed the petition on for respondent number 1. Don't insist for an early date when you have not done your part. File your requisites within a week, and then we give a date in early June.
Yes, sir.
On that they will decide.
12 June.
Highly obliged, Your Lordship.
Daily list for admission, item 14.
Yes.
May please, Your Lordship. Lordship, may the matter be taken up after some time. Lordship, my senior, Mr. K. N. Chaudhary, is on legs. So would like to move this matter.
Tomorrow we have many other matters. Next week, then.
Lordship.
We would not know there is a meeting also at 4 o'clock. I spread for the apollo. Re-notify on next week for the same day, but still.
29-4.
Much of the.
Item 15.
My lord, this PIL has been filed, my lord, for regarding my operation of brick kiln in violation of the environment norms, my lord. As per the norms, within 100-meter radius should not be any school, my lord. Page 24, this is the rules. Clause 2.3.2.2. Minimum 500 meters should be there from the brick industry to the school. But as per information received from the circle office, page 17, there is a distance of 100 meters, and the brick industry is fallen under the agricultural land. But as per the guideline, it should be non-agricultural land.
This public interest litigation has been filed with the court grievance that the Pollution Control Board Assam and other respondent government authorities have allowed the private brick kiln factory, bracket respondent number 8, to operate illegally in a densely populated residential area. Right next to a primary school. The contention of the petitioner is that the brick kiln in question is located on agricultural land in the middle of the village and is about 90 to 100 meters away from a school, from a government primary school. Apart from causing severe air pollution through smoke and dust, it has also resulted in damage to the nearby crops, which is the main source of income for the villagers. The information received by the petitioner is that the brick kiln is operating without valid environmental clearances and without renewing its consent to establish or consent to operate under the Air Prevention and Control of Pollution Act 1981. Despite protest by local persons before the authorities, no action has been taken till now. Mr. Barua accepts notice on behalf of response number 1.
No, I appear for 2 and 3. And I appear on behalf of the pollution law.
Mr. Barua, learned government advocate, accepts notice on behalf of response number 2 and 3. Whereas Ms. Sumitra Sharma, Ms. S. Sharma accepts notice on behalf of response number 5. 1, 4, 1 to 8, 1 to 7. 1 to 7.
The environment and forest, they have.
You inform, but you accept notice, you inform.
I will.
1 to 7. Let notice be issued to respond number 8 on steps being taken by the petitioner within a period of 2 weeks, both notes returnable on your date in July. But in the meantime, necessary affidavit on behalf of the respondents, the government, the pollution control board and the state of Assam shall be filed. In the meantime, we have said no, shall be filed. Re-notify your date, returnable date. Which date we have given?
14/7.
14/7.
Obliged.
Item 16.
Yeah, my brother has some difficulty in hearing this. But let this case go out of my list and be placed before a bench of which officers. Justice Arun Dev Chaudhary gave Arun Dev Chaudhary gave one part. Let this case be placed before the Chief Justice and the administrative side for giving an appropriate.
Item 17.
May it please your lordship. My lord, the IOCL has come before your lordship in an appeal, the promotional matter, my lord. The gist of the matter is that
Can you give us 2 minutes?
my lord,
What's your name?
N. Barua.
Flip name. Maybe. I don't remember the name to be honest. I don't feel good referring to them as human advocate.
My lord, unfortunately, my name is not reflected in the cause list as well. My colleague's name is there.
For the Apollo, Flash Indian Oil Corporation Limited, and 7 others. We have heard some. Who's appearing for respondent? Yes, you're there, why do we should notice? Argue?
My lord, notice was issued in the delay condemnation petition, therefore.
So he's here. Mr. Patki, you are here.
I'm here for, so far the appeal is concerned, no notice or this.
And it doesn't matter, no. Appeal, if you're ready, we will hear you.
Or any other.
Why you're not prepared today?
Your lordship, which will wants here and.
No, wants to means it is because you have got an
Will
order.
what?
You have got an order in your favor from the single judge.
My
He's opposing it. He says that no, it is for all the clusters. The MOS is applicable to all the clusters. The single judge says that it is only with respect to cluster A and cluster B. You are in cluster C, but a single cadre post.
My lord.
There is some justification of the Indian Oil Corporation. Get ready in the matter and then argue.
I don't know.
Get ready in the matter and then argue. Would you like to respond to this by an affidavit? No, not required.
Not required.
Not
About affidavit required. You know what happened? This is the promotion in respect of workmen to the officials cadre. That the cluster promotion is not applicable to us. That's the difficulty here. Here the promotion in respect of workmen to the official grade.
It is not an intercluster.
No, not in intercluster. It's not an intercluster.
What do you have to say to this?
My lord, I'll need to produce the copy of that MOS dated 5/11/92 because it revolves entirely on that MOS. Then it has not been annexed with the written.
Why?
My lord, that because I have not been provided a copy of that, I had already requested for 2 copies.
A copy. You represent the corporation.
My lord, that copy I requested, I needed the copy. My lord, because our contention is that it is an intercluster promotion because.
Where is that MOS? Let's see.
Well, that MOS is annexed, but I have.
Mr. Patki, do you have the MOS?
Yes, my lord. Well, they have supplied it.
Anyway, you annex it.
I know. I have because I have annexed the 2015 plus MOS, not the 92.
Learned Standing Council for the IUPL. At the outset, submitted. It would be necessary to bring in the MOS dated 5th of November 1992, which has not been annexed, which has not been brought on record of this appeal. Let the aforementioned MOS dated 5th of November 1992 be brought on record by the next date, re-notify on. Then in that case, you comply with the orders. We'll see. Comply with the orders. If you were ready today, we would have done something.
17 June.
July.
21st July.
Anyone caveat, keep ready on merits because this.
No, my lord, I am not filing any caveat because of condonation of delay. Notice was issued to me, my lord.
So you must be having instructions from your client.
Yes, I have.
This matter. Then you.
No, I have otherwise,
Item 18.
Yes, Mr. Boyan.
My lord, my body is my enemy, my lord, according to them, my lord.
All of us, most of us at our age become overweight. But this is the time when he was seeking employment and there is a complete bar.
My lord.
And not a kg or 2, 12 kgs.
My lord, only one, my lord, if I am overweight, my lord, that is correct, my lord. It is very difficult to, my lord, get in the appointment, my lord, or pass the test. But my lord, if we go by the medical examination, I just want to draw my lordship's attention to page 80, my lord. This is the initial record they have maintained. They have straight away says, my lord, that I am overweight by 12 kgs. Now, what was my weight at that relevant period of time, my lord? In this form, we have not find it out. But when I go for the review, my lord, then they have reported, my lord, that I am 71.5 kg. And the, my lord, unfit on account of overweight. So what was the, my lord, exact weight I at that point of time recorded that is missing in this form, my lord?
On 1911, his weight was taken, Lordship, and 2011-25, his overweight by 12 kg.
No.
19, page 80 is on 1911-25.
1911, that is, no.
And 2011-25, 71.5 kg, overweight by 12 kg. Obviously, he will be 71.5 kg.
But at the time of test, they have not recorded, my lord. Only on the review, they have recorded the weight, my lord.
You should have given one line in your petition that according to you, the weighing machine used was not given correct, correct weight.
Correct weight.
Whenever I stand on a weighing
Weight
machine,
machine,
which I do quite regularly,
My lord,
I think that the machine is not working properly. It always shows higher weight than what I expect.
my lord. My lord,
But the fact remains that I have that kind of a weight.
my lord, my
But
lord.
you expect that the machine will show less.
My lord, the guideline says that the plus minus 5 can be done.
So this is 12.
12.
No, according to them, it is 12, my lord. Now, I have, my lord, in my repetition, my lord, I have categorically say, my lord, that in what manner the weight had been done, my lord, I could not even get a glimpse of the machine also that, my lord, it was not in a very,
You ask for it.
in a very restless manner, my
It was
lord.
in your presence, and perhaps the learned second judge also had the occasion to see the pen drive.
Video, my lord. The video has been exhibited by my learned friend, my lord. Exactly. My lord, we have found out a guideline today only, my lord. Their
It's
guideline.
sorry for you, Mr. Boyan, but we can't help you.
No, my lord, may I pray, my lord? One guideline we have find it out today, my lord. The revised guideline dated 21.
What revised guidelines?
No, they have revised the guideline, my lord. The guideline which they have, we have annexed in our petition is of 2015, my lord. And there is a recent guideline of 2021, my lord. Wherein, my lord, it has been categorically said that under such situation, a thorough investigation is required to be done if the medical board come to such a conclusion, my lord. But that has not been done, my lord, in my case.
What is the guideline? I just missed it.
My lord, the guideline,
Annexed with the
no, guideline dated May 31, 2025, my lord, Government of India, Bharat Sarkar, Ministry of Home Affairs, my lord, Griha Mantralaya, my lord.
No, this was decided in 2015.
No,
And the
my lord.
guidelines of 2021.
No, my lord, the advertisement is of, my lord,
24.
24, my lord. So this guideline will follow, my lord. So, my lord, may I be permitted to just to bring on that guideline on record, my lord? My lord can have some rescue can be done, my lord.
All right.
My lord.
Results were declared.
My lord.
He has lost it only because of his weight.
Lord.
You have concluded the process.
My lord.
People have been employed.
Lordship.
There are very little chances of
My lord.
Mr. Bhuyan succeeding. If he wants a time to bring on record certain documents, let him do so.
Lordship.
We are not interfering with the judgment of the single judge at the moment.
Lordship.
Why do you have to be so stingy,
No.
Mr. Roy?
No.
He began his argument. He was on a back foot since the beginning. He says that my body is against me.
Lordship.
So
That's why I've not said anything.
let his mind not be put on the back foot. Let him file that affidavit. Okay, as prayed for by Mr. Advocate for the matter is adjourned. We don't require that, but for your satisfaction. Today we are not dismissing it. On the other day, when we look at it from a different point of view, you may expect some better star position.
Well, deeply.
1-6. Item 19 to 22.
Mr. Das, Honorable Justice Vinod Chandran has given a judgment.
But I have a copy.
So therefore, all this has become infructuous. All this has become infructuous.
Yes, but I have an intense desire to persuade your lordship, subject to permission, obviously, before your lordship.
Would that not be a waste of time, Mr. Das? Supreme Court says so. And even even the rules, even the new ROP rules, they say it is not and, it is or. Now look at this.
Right.
We have heard it once, no?
Yes,
Against that order, they filed a review. Review also rejected now. Against that order, review.
It says all employees who were in service on 31st of March 2016 or who may have been appointed on or after 1st of April 2016 shall draw the pay. Where is the confusion? Why this matter actually was argued? Maybe on the grounds of FR 56 or something. FR, which is that rule FR?
no, true. Honorable Apex Court has,
Rule 32A, madam.
FR 56A.
the Honorable Apex Court had,
Don't waste your time over all this.
but Rule 1B, which was, sorry, my lord.
Sorry.
Why are you arguing all this?
Do you think
That is my, my lord, that's why at the very beginning, my lord, I said, it is my intense desire to persuade,
No, desire will not do.
subject to permission. my lord.
Desire will not do. We are deciding in a judicial forum. So
Correct.
we are deciding on the same point. Your desire
Lord, we filed a review petition only on the
that
ground.
dismiss. That also dismiss.
Dismissed, only on the ground that it was overlooked, the rule 1B was overlooked, my lord. That was the thing.
in view of the judgment passed by the Supreme Court, passed by the Honorable Supreme Court in Civil Appeal number 14559 of 2025, upon special leave petition number C22297 of 2024. And the review petition also having been dismissed, the appeal. All these appeals stand dismissed.
Highly believe.
Item 23.
And even otherwise, it should not have gone to Supreme Court because the wordings are very clear. Now, notwithstanding the fact that the last day of the month in which he retires would be the date. So this is a deeming date that he remains in service. So if he remains in service on that day and the rules say that anybody who was in service on 31/1/2016, he shall be the beneficiary of the new rules. So
Rule
where is
1,
the question?
my lord, Rule 1B says the rule will come into force from 1/4/2016.
But then has it not been explained in the, it's absolutely unambiguous.
Honorable Apex Court went on the pretext, my lord, subject to, my lord, went on the pretext that the rule came into force from 31/3/2016.
No. That
Yes.
is the reason. No.
Lord, I can
These
point
things-
out below, but
Are we here to correct
No,
the Supreme
no,
Court
no,
judgment?
no,
The
no.
question is this, we have read the rules. It says that anybody who gets appointed and continues thereafter from 1/4. Otherwise, it is 31/3. Finished.
highly obliged.
Item 23.
I have entered appearance for the respondent of folder. But I pray for some time to file an affidavit in the matter.
Why, Mr. Nath, you are always very prompt in filing your response.
Here, my lord, I could file the Wakalatnama very recently, my lord. I have
Massive corruption and show.
no, these allegations are not correct.
But your oral environment would not do.
I'll
Mr.
file.
Sikdar has come up with a very
That's
specific allegation.
No, I'll file the affidavit. No, in fact, none of the things are otherwise. I'll file the affidavit.
And there is Mr. Nath. No. Mr. Nath. Learned government advocate. Senior government. Learned senior government advocate. Who appears to respond number 4 submits that by the next date, response affidavit shall surely be filed.
Lot.
Let this matter come up for consideration upon. We are giving you date in sometimes in July.
Lot.
First week of July.
I'll file. Deep level.
15 July. Item 25.
कौन सी डेट पे सब सुन रहे हैं? All these RCC courts.
Yeah, tomorrow, my lord, it has been fixed tomorrow.
Tomorrow.
It came up.
Last day, it just came up on yesterday, lord.
So when all these matters are listed?
Tomorrow, lord.
Let this matter come up for consideration tomorrow, that is on so and so date, along with writ petition. Give the numbers.
Yes, sir.
Item 27.
My lord. The respondent has filed their affidavit in opposition, my lord.
They're fine.
They have filed. We would like to file our reply rejoinder, my lord. We only place two documents. Short. This is the number 27.
Mr. Bhaskar Datta, learned senior advocate for the appellant, seek some time to file a rejoinder petition. A rejoinder affidavit for the need. Let that be done by the state. Re-notify on
20.
July.
Yeah.
July.
28 July. 20. Item 29.
So this is.
The health was given chance to.
Who appears for the health department?
My esteemed.
Yes, Mr. Gogoi.
It is otherwise covered, Gwalpara district, When Gwalpara was allowed, they were part of the original writ petition. Only few came to the honorable court in the first bit, now they in the second. But the fact remains that in the earlier cases.
So in terms of that judgment,
Yes, but there were protections given to the earlier appellants that we will keep certain vacant posts. Here, they approach after the orders, passed by the honorable court. Now, that's the difficulty.
no, that protection will go.
No, in those cases, in the writ
Yeah, there
proceeding,
are very initial, there was the interim that we'll have to keep certain posts for the appellant.
but ultimately,
Ultimately, yes, it has been status.
but there are distinctions between other cases.
Others are different,
But
Others are different.
many
But
retail-
Gwalpara and Dibrugarh,
Many writ appeals are filed.
yes, those are pending. Then we'll file an affidavit, indicating the difference.
Allowed in terms of reclamation. Both Mr. Gogoi, we have heard both Gogois. Allowed in courts of judgment dated so and so past. Takes the details from it.
Item 30.
This is the same flood issue, artificial flood issue, here we have done. So, and then commissioner has already given some report, and that commissioner, after that also the government also has given some another additional affidavit they have filed. They said they are going to submit some commission, they have formed some committee. And that committee is supposed to give some report. Again, they are going to analyze the commissioner's report like that.
You are walking against time. Now that committee was constituted, committee has given recommendations. The allegation is that it has not been, you should have been the first person to tell us this. Mr. Gogoi has to say whether those recommendations have been adopted, they have been executed or what.
Well, this affidavit was filed on 15/12. So recent
No.
development.
File a fresh affidavit.
Yes, that's why.
It's very, very necessary.
Yes.
At the instance, but must do it by the next.
Yes, yes. We will.
Very important, Mr. Gogoi.
I understand.
So no, in the meantime, new industries are growing in that area, and then, yes, I got this report now only. And then this time also this flood situation is
We are
very
not
bad.
asking response number 6 to 10. You have to take care.
Lordship.
We'll not be dealing with them.
No, it is a deputy commissioner will have to, my lord, place the entire updated.
So therefore you file a
Yes,
detailed.
we will file an updated.
Mr. We go. The detailed latest shall forthwithly be filed by the next day. Re-notify. We are giving you 4 weeks time.
No.
Spend some time over it. Let us know. Otherwise, we come down heavily. It doesn't look.
Lordship. No.
Now, anybody, most of my judges, while coming back from airport, they complain
Mine.
to their chief justice that this is what is happening.
Lordship.
File your petition, file your affidavit. What have you done? If you have not done anything, please utilize this time to do.
Lordship.
Let us give them 6 weeks.
Right.
6 weeks.
24 July.
Alright.
Item 31.
You file your affidavit, no?
We already filed, we have complied in the entire state of Assam. It is only the district of Kokrajhar which is facing a little bit of problems, considering the fact that the building was made and yet it was a defective building. And to that effect, I filed the affidavit yesterday, Your Lordships. Only in the district of Kokrajhar. Otherwise, almost all the districts have complied.
You petition.
Passing it over, Your
This
Lordship.
is a young boy.
Yes, he is the petitioner. That should, I think,
Let it be done in his presence.
definitely.
There is no appearance on behalf of the petitioner. The land counsel for the respondents are present. Let this matter come up for consideration next week.
Let's.
30 April 30. Item 32.
This matter may come up in the next, my lord.
SLA number so and so is pending adjudication.
Yes, my lord.
It has not been decided.
No, my lord. In the meantime, my lord, dishonorable court also, my lord, passed some, my lord, detailed judgment in this.
Of SLA number 30056 of 2017, pending adjudication before the Supreme Court. This case is adjourned to your date times after reopening in July.
15 July.
Applicable.
Item 33.
But all the cases referred by the Union of India was the judgment was delivered on 24/3/2026, whereby the appeal preferred by the Union has dismissed.
No. What is happening in Supreme Court? Which was decided.
Dismissed.
What does the Supreme Court say?
It says that the condonation of the minimum pension period.
We'll see from some other day. Let's see.
Is that paragraph 41 onwards, no?
See tomorrow. See tomorrow.
Well, tomorrow there is a problem. My personal difficulty. Can it be any other day, man?
Huh? Friday.
Friday 24.
Friday.
24/4.
Pending. All right.